This is part 52 as far as our series of lectures is concerned, and in this part we intend to discuss chapter 26 of the Criminal Procedure Code, which deals with provisions as to offences affecting the administration of justice, and it starts right from section 340 up to section 352 of the Criminal Procedure Code. Section 340 lays down procedure in cases mentioned in section 195. So in order to understand this, it is necessary for you to have reference back to section 195. Go through the enumeration as far as the offences are concerned, and this we have dealt at the time of restriction with respect to the power of the court to take cognizance of an offence as per the provisions of the Criminal Procedure Code, when we were dealing right from section 190 up to 199. And there we learn that 195 up to 199 are the exceptions with respect to, or these are the statutory restrictions with respect to the power of the court to take cognizance of an offence. So now it says, when upon an application made to it in this behalf or otherwise, any court is of the opinion that it is expedient in the interest of the justice that an inquiry should be made into any offence referred to in clause small b of section 1 of section 195, which appears to have been committed in on relation to a proceeding in that court, or as the case may be, in respect of a document produced or given in evidence in proceedings in that court, such court may, after such preliminary inquiry, if any, as it thinks necessary, a. record a finding that effect, b. make a complaint thereof in writing, c. send it to a magistrate of the first class having jurisdiction, d. take sufficient security from the appearance of the accused before such magistrate, or if the alleged offence is non-bailable and the court thinks it necessary so to do, send the accused in custody to such magistrate, and e. bind over any person to appear and give evidence before such magistrate. Subclause 2 says, the powers conferred on a court by subsection 1 in respect of an offence may, in any case where that court has neither made a complaint under subsection 1 in respect of that offence, nor rejected an application for the making of such complaint, be exercised by the court to which such former court is subordinate within the meaning of subsection 4 of section 195. Subclause 3 says, a complaint made under this section shall be signed, a. where the court making the complaint is a high court, by such officer of the court as the court may appoint, b. in any other case by the presiding officer of the court, or by such officer of the court as the court may authorize in writing in this behalf. And subclause 4 says, in this section court has the same meaning as in section 195 of the Criminal Procedure Code. With this now, section 341 deals with appeal, provision regarding appeals, and it says, subclause 1 says, any person on whose application any court other than a high court has refused to make a complaint under subsection 1 or subsection 2 of section 340, or against whom such complaint has been made by such court, may appeal to the court to which such former court is subordinate within the meaning of subsection 4 of section 195, and the superior court may thereon, after notice to the parties concerned, direct the withdrawal of the complaint, or as the case may be, making of the complaint which such former court might have made under section 340, and if it makes such a complaint, the provisions of that section shall apply accordingly. Subclause 2 says, an order under this section and subject to any such order, an order under section 340 shall be final and shall not be subject to revision. Section 342 deals with power to order costs, and it says any court dealing with an application made to it for filing a complaint under Section 340 or an appeal under Section 341 shall have power to make such order as to cost as may be just. Section 343 lays down procedure of magistrate taking cognizance, and it says, subclause 1 says, a magistrate to whom a complaint is made under Section 340 or Section 341 shall, notwithstanding anything contained in Chapter 15, proceed as far as may be to deal with the case as if it were instituted on a police report. Subclause 2 says, where it is brought to the notice of such magistrate or of any other magistrate to whom the case may have been transferred that an appeal is pending against the decision arrived at in a judicial proceeding out of which the matter has arisen, he may, if he thinks fit, at any stage adjourn the hearing of the case until such appeal is decided. Section 344 deals with summary procedure for trial for giving false evidence, and it says, subclause 1 says, if at the time of delivery of any judgment or final order disposing of any judicial proceedings, a court of session or a magistrate of the first class expresses an opinion to the effect that any witness appearing in such proceeding had knowingly or wilfully given false evidence or had fabricated false evidence with the intention that such evidence should be used in such proceeding, it or he may, if satisfied that it is necessary and expedient in the interest of the justice that the witness should be tried summarily for giving or fabricating, as the case may be, false evidence, take cognizance of the offence and may, after giving the offender a reasonable opportunity of showing cause why he should not be punished for such offence, try such offender summarily and sentence him to imprisonment for a term which may extend to 3 months or to fine which may extend to 500 rupees or with both. Subclause 2 says, in every such case the court shall follow as nearly as may be practicable the procedure prescribed for summary trial. Subclause 3 says, nothing in this section shall affect the powers of the court to make a complaint under Section 340 for the offence where it does not choose to proceed under this section. Subclause 4 says, where after any action is initiated under subsection 1, it is made to appear to the court of session or magistrate of the first class that an appeal or an application for revision has been preferred or filed against the judgment or order in which the opinion referred to in that subsection has been expressed, it or he shall stay further proceeding of the trial until the disposal of the appeal or the application for a revision as the case may be, and thereupon the further proceedings of the trial shall abide by the result of the appeal or application for revision. 345 deals with procedure in certain cases of contempt, and it says, subclause 1 says, when any such offence as is described in section 175, section 178, section 179, section 180 or section 228 of the Indian Penal Code is committed in view or presence of any civil, criminal or revenue court, the court may cause the offender to be detained in custody and may at any time before the rising of the court on the same day take cognizance of the offence and, after giving the offender a reasonable opportunity of showing cause why he should not be punished under this section, sentence the offender to fine not exceeding 200 rupees and in default of payment of fine to simple imprisonment for term which may extend to 1 month unless such fine be sooner paid. Subclause 2 says, in every such case, the court shall record the facts constituting the offence with the statement, if any, made by the offender as well as finding and sentence. Subclause 3 says, if the offence is under section 228 of the Indian Penal Code, the record shall show the nature and stage of judicial proceeding in which the court interrupted or insulted was sitting, and the nature of the interruption or the insult. With this now, section 346 deals with procedure where court considers that the case should not be dealt with under section 345. Subclause 1 says, if the court in any case considers that a case accused of any of the offences referred to in section 345 and committed in its view or present should be imprisoned otherwise than in default of payment of fine, or that a fine exceeding 200 rupees should be imposed upon him, or such court is for any other reason of opinion that the case should not be disposed of under section 345, such court, after recording the facts constituting the offence and the statement of the accused as hereinbefore provided, may forward the case to the magistrate having jurisdiction to try the same, and may require security to be given for the appearance of such person before such magistrate, or if sufficient security is not given, shall forward such person in custody to such magistrate. Subclause 2 says, the magistrate to whom any case is forwarded under this section shall proceed to deal with as far as may be as if it were instituted on a police report. Section 347 deals with when a registrar or sub-registrar to be deemed a civil court, and says, when the state government so directs any registrar or any sub-registrar appointed under the Registration Act of 1908 shall be deemed to be a civil court within the meaning of section 345 and 346. 348 deals with discharge of offender on submission of apology, and it says, when any court has under section 345 adjudged an offender to punishment, or has under section 346 forwarded him to a magistrate for trial for refusing or omitting to do anything which he has lawfully required to do, or for any intentional insult or interruption, the court may, in its discretion, discharge the offender or remit the punishment on his submission to the order or requisition of such court, or an apology being made to its satisfaction. Section 349 deals with imprisonment or committal of persons refusing to answer or produce document, and it says, if any witness or person called to produce a document or a thing before a criminal court refuses to answer such questions as are put to him, or to produce any document or thing in the possession or power which the court requires him to produce, and does not, after a reasonable opportunity has been given to him so to do, offer any reasonable excuse for such refusal, such court may, for reasons to be recorded in writing, sentence him to simple imprisonment, or by warrant under the hand of the presiding magistrate or judge, commit him to the custody of an offence of the court for any term not exceeding 7 days, unless in the meantime such person consents to be examined and to answer or to produce the document or thing, and in the event of his persisting in his refusal, he may be dealt with according to the provisions of section 345 or section 346. With this now, section 350 deals with summary procedure for punishment for non-attendance by a witness in obedience to summons. Subclause 1 says, if any witness being summoned to appear before a criminal court is legally bound to appear at a certain place and time in obedience to the summons and without just excuse neglects or refuses to attend at that place or time, or departs from the place where he has to attend before the time at which it is lawful for him to depart, and the court before which the witness is to appear is satisfied that it is expedient in the interest of justice that such witness should be tried summarily, the court may take cognizance of the offence, and after giving the offender an opportunity of showing cause why he should not be punished under this section, sentence him to fine not exceeding 100 rupees. In every such case, the court shall follow, as nearly as may be practicable, the procedure prescribed for summary trial. Section 351 deals with appeal from conviction under section 344, 345, 349 and 350. And subclause 1 says, any person sentenced by any court other than a high court under section 344 and section 345, section 349 or section 350 may, notwithstanding anything contained in this code, appeal to the court to which decrees or orders made in such court are ordinarily appealable. Subclause 2 says, the provisions of chapter 29 shall, so far as they are applicable, apply to appeals under this section, and the appellate court may after alter or reverse the finding or reduce or reverse the sentence appealed against. Subclause 3 says, an appeal from such conviction by a court of small causes court shall lie to the court of session for the sessions division within which the court is situated. Subclause 4 says, an appeal from such conviction by any registrar or sub-registrar deemed to be a civil court by virtue of directions issued under section 347 shall lie to the court of session for the sessions division within which the office of such registrar or such registrar is situated. With this now, the last section 352 deals with certain judges and magistrates not to try certain offences when committed before themselves. And it says, except as provided in section 344, 345, 349 and 350, no judge of a criminal court other than a judge of a high court or magistrate shall try any person for any offence referred to in section 195 when such offence is committed before himself or is in contempt of his authority or is brought under his notice as such judge or magistrate in the course of a judicial proceedings. With this we are dealt with offence provisions regarding offences affecting administration of justice, right from section 340 up to section 352 of the Criminal Procedure Code.